We're with Ryan Tagnelia. Ryan is a criminal lawyer in San Diego, and he's agreed to answer an online question that's specifically related to domestic violence. And so here was the question. This was from Eliza. My husband and I were in a really bad fight, and he threatened to kill me. I was scared and called 911, and charges were pressed against him. We have solved our problems, and now I want to drop the charges. Can I do this, and will there be any record of it?
Okay. Yeah, thanks, Lisa. This is a really common question. It's not at all uncommon for couples to get into, either a heated argument or, get into a fight that, maybe escalates to a level where the police are called, but then later on they patch up their differences and they want the whole thing to go away. And unfortunately, the criminal justice system does not work that way. Once the police are called, the matter is out of the citizen's hands. The way criminal prosecution works, and this is true for minor offenses up to major offenses, is the police, when they are done investigating a crime, whether that's talking to one witness or whether it's doing all the CSI stuff that you see on TV, when they're done investigating a crime, they take all the materials they had they compiled for the investigation, and they send it over to the district attorney's office. And once the DA has it, a deputy district attorney, so a lawyer that works for the government, reviews all the evidence and decides whether or not to file a case. They could reject it, meaning that the case is never filed at all, or they can file the case, and they are allowed to file the case over the objection of the victim. And so once the case is filed, it's filed, and they are not at all beholden to the victim. So the victim comes in and says, "I want you to dismiss the whole thing. I don't want this, I don't want this anymore." They'll certainly take that into account when they're moving forward with their case, but they're not at all obliged to just simply dismiss it or drop the whole thing. So it's important whenever you have situations like this to get a jump on it. It's much easier usually to maybe help the DA decide to not issue the case than it is to get them to agree to dismiss it after the case is filed. So getting an early starting, getting early contact with the DA's office is important. So if you find yourself in this situation, it is important to contact an attorney right away. However, if the case has already been filed and it's already going to court, while the law says you as the victim can certainly make your statements known, the prosecutor is not at all obligated to follow your wishes.
Okay, well, I hope that answers your question. If you have other questions for Ryan, just post them in the comments section at the bottom of the video. Thanks, Ryan.
Yeah, and if you have any further questions or you have more specific questions, give me a call, 619-577-0868. Thanks.
Thanks, Ryan.